Good day. My name is Mark Mellor. I'm an attorney here in Riverside, California. I've got a number of contractor and homeowner, property owner clients in Crestline, California. So I thought I'd do this video to give you some pointers on mechanics lien and mechanics lien law in case you're facing those issues. What are some of the things you want to take a look at? Well, the first thing you want to ask yourself is, am I in direct contractual privity with the owner of the property at issue? Whether you're an owner or a contractor, that's the first question. And the reason that's the first question is that's going to trigger whether you have to serve by certified mail return receipt requested California's 20-day preliminary notice. If you're not in direct contractual privity with the owner, you've got to serve that notice by certified mail return receipt on the owner of the project, the lender, if any, on the project, and the general contractor, if any, on the project, to let them know that you're there doing the work. If you are in direct contractual privity with the owner, you don't have to do a 20-day preliminary notice. But that's important if you're not, because without the 20-day preliminary notice, you have no right to record a mechanics lien. And when do we record the mechanics lien? Well, the first time we can record a mechanics lien, you want to do that within 90 days of you leaving the project. So, for example, if you completed your scope of work and 60 days rolls around, you want to make sure you record your mechanics lien in the county where the property's at so that you can preserve your mechanics lien rights. If you let the 90 days go by and you don't record your mechanics lien, you lose those rights to record the mechanics lien. So if you filed your 20-day preliminary notice and you record your mechanics lien within the first 90 days after leaving the project, the next step we want to take a look at is, have you sued to enforce your mechanics lien rights? And within 90 days after recording the mechanics lien, you have to sue in a court of law to foreclose on your mechanics lien. For that, you should probably see an attorney if you don't have one, and sue to enforce your mechanics lien rights. As long as you follow that time frame, if you're not in direct contractual privity with the owner, you serve your 20-day preliminary notice. Within 90 days of leaving the project, you record your mechanics lien. And within 90 days of recording the mechanics lien, you file a lawsuit. You can enforce your mechanics lien rights. Now, if you're a homeowner or a property owner and you're dealing with a contractor that hasn't followed those steps, then you want to see an attorney about a summary motion to have the mechanics lien expunged from your property record without having to deal with a lawsuit later on for that, because the mechanics lien is of no longer use to the contractor at issue. And that's because he hasn't followed the statutory framework. And in California, the statutory framework is strictly liable. In other words, the contractor has to strictly follow that time frame, and if they fail to, the mechanics lien is no longer valid. And there's a summary motion to dispose of a mechanics lien if that contractor hasn't followed that particular provision of the code. So when you're looking at these issues of mechanics lien, know that you have to strictly follow the code, and there's a lot of time frames to be aware of. You want to make sure that you are aware of those and you follow those, because it makes my job a lot easier as an attorney if I've got to collect money for you on a job where you didn't get paid, or if you're a property owner and you've got a unworthy contractor trying to get paid surreptitiously and they're not entitled to be paid. So those are some of the things to look at. If you've got some personal issues or some particular circumstances you want to go over and ask questions with, feel free to make an appointment in my office and I'd be happy to talk with you about your particular issue.